A very good evening to all of you from the legal fraternity, law students, and all those who are joining in from the non-legal fraternity for the webinar series organized by the Bar Association of Sri Lanka. And today is a very special day as we mark the 40th webinar series conducted for the benefit of the legal fraternity, as well as those who are interested in expanding their knowledge on legal issues in Sri Lanka. So as we move on to the discussion today, let me first and foremost thank everyone who has been behind organizing the last 40 webinars, which has obviously not been an easy task, which has been a very tiring effort by the Bar Association of Sri Lanka. So first and foremost, let me welcome the Secretary of the Bar Association of Sri Lanka, Mr. Rajiv Amarsurya, to speak to you right before we move on to this discussion.
Thank you, Shahara. A very warm welcome to all of you this evening to this 40th webinar in Series 1 of the Bar Association of Sri Lanka. When we launched this webinar series last year on 9th of May, BASL President, Mr. Kaling Inditisa President's Council, said that it was a historic day for the BASL. 10 months and 40 weeks down the line, celebrating our 40th webinar today, I must say this is a historic day as well. As a BASL, having embraced technology and commencing this series, has relentlessly pursued for 10 months non-stop, and this is also probably the first, and will make history. Organizing these 40 webinars every Saturday at 5:30 p.m. has not been an easy task. To add to this, we also have our BASL singular webinar series every Tuesday at 7 p.m. and we have completed almost 15 webinars already. I take this opportunity to thank the close to 200 resource persons for the knowledge they have shared through these webinars, which has been invaluable and of immense value to the profession. I also take this opportunity to thank all the compeers who have supported the webinar series 1, including Ms. Tanya Gunawardana, Ms. Uma Vijayasuriya, Mr. Shehara Herath, Mr. Damida Vijayaratna, Ms. Senuri Munasinghe, and Ms. Isudi Jayawardana for their commitment and support. I must make special mention of our Assistant Secretary, Mr. Pasindu Silva, and Ms. Anne Devananda, Attorney at Law, without whom we could not have been able to keep this series running for so long. Also, special mention of Ms. Ushan Ubiratna, Attorney at Law, who introduced me to the concept of webinars around September 2019 and who convinced me of the value of webinars, which I included in my action plan for the BSL before the onset of COVID-19. Also, special mention to the other members of the Management Committee of the BSL, led by the President, Mr. Kaling Inditisa President's Council, for all the guidance and support provided at all times to make this series a success. Last but not least, to the BSL team comprising our CEO, Mrs. Surani Samarasekara, Head of IT, Mrs. Saranga Hettiarachchi, Mr. Ture Singham Prakalathan, and Mr. Kalinga De Silva of the Program Office, and everyone else for all the support. I also thank very much the expert panelists today, our 40th webinar. And now, let me hand over the proceedings to Shehara. Over to you, Shehara.
Thank you very much, sir. And once again, before we begin, a big thank you for the leadership taken in this effort in giving legal knowledge, not only within the legal fraternity, but also to everyone, not only in Sri Lanka, but throughout the world who are interested about knowing the law, who are interested about knowing different aspects and concepts of law. And now, ladies and gentlemen, let me welcome you to the discussion session of today's webinar series, the 40th webinar series organized by the Bar Association of Sri Lanka. And today we are going to discuss about winding up applications. And we have Mr. Janaka Balasurya as the moderator of today's webinar series. And we would like to welcome the distinguished panelists who have dedicated their time and effort in being here to educate all of you. So first and foremost, let me welcome Mr. Palita Kumar Singha, President's Council. So he was a former president of the Colombo Law Society. It's a great honor to have you in this webinar series, sir. And then let me welcome Mr. Aravinda Rodrigo, President's Counsel. And Mr. Aravinda Rodrigo is the head of litigation of FJ&G Disarums, and he is a barrister of Garrison, England and Wales, and an advocate of the Supreme Court of Sri Lanka. And he has experience in the legal sector for more than 20 years. And now, once again, on behalf of the Bar Association of Sri Lanka, let me welcome Hiran Dialvis. Mr. Hiran Dialvis, attorney at law, is a senior legal counsel practicing in Colombo for more than 25 years, specializing in civil and commercial law, financial, securities, litigation, as well as commercial arbitration. And he is a law graduate from the University of Colombo, and he holds a postgraduate qualification from the University of London in international dispute resolution. And ladies and gentlemen, let me also welcome Lakshman, Mr. Lakshman Jayakumar. Mr. Lakshman Jayakumar counts over 18 years of active practice, having commenced his career in chambers of Sri Lanka's foremost commercial lawyer, Dr. K. Kanageshwaran, President's Counsel, and he has an LLM in commercial law from the University of Colombo. And now, ladies and gentlemen, to begin the discussion session of today's 40th webinar organized by the Bar Association of Sri Lanka, I most humbly welcome Mr. Janaka Balasuriya, attorney at law, to head the proceedings. I think Mr. Janaka Balasuriya should unmute his mic. Yes.
Yeah. Thank you, Shihara, for that introduction. Small correction before we commence. It's my name is Janaka Balasuriya, not Balasuriya. Thank you for that anyway. As it was stated, ladies and gentlemen, this is quite a special webinar today because it is the 40th of its kind organized by the Bar Association of Sri Lanka. It is somewhat special for me also because I was the moderator for the 30th webinar. So what a pleasant coincidence. We must, in the meantime, congratulate the Bar Association and its office bearers for this yeoman work. Ladies and gentlemen, our first speaker for today is Mr. Palitha Kumar Singh, President's Counsel, who is well versed in the area of winding up of companies. It's our pleasure and privilege to have you here with us in this seminar. Before we move on to his speech, let me make a very brief overview to clear out some fundamental misconceptions about winding up. Winding up of a company, in a nutshell, is the process of bringing an end to a company. The company's assets are sold off and then used to pay off the company's debts. Any excess proceeds are then returned to the shareholders of the company. Here, our webinar today, we are dealing with winding up of companies and not about bankruptcy. In getting into terminology right, we should refer to the term winding up or even liquidation when referring to this process of winding up of a company. In Sri Lanka and in very many other jurisdictions like Singapore, Malaysia, and Australia, to name a few, these are the terms to be used. On the other hand, the term bankruptcy is for individuals and where the individual may be adjudged bankrupt or insolvent. Similarly, winding up does not mean the extinction of a company, and it is only upon by dissolution that the company ceases to exist. Dissolution means striking off its name from the records of the Registrar of Companies. You may imagine now how vast and complex the area of subject that we are going to deal with today. That said, ladies and gentlemen, in such a context, it's vital that we get familiarized with the legal regime relating to winding up. which is mainly governed under the provisions of Part 12 of the Companies Act number 7 of 2007 and the Companies Winding Up Rules 1939. And we have the best speaker to talk about such with us today. As you may be aware, the provisions of the Companies Act originate from the earlier Companies Act number 17 of 1982 with few modifications, and the rules of 1939 subsisted over several decades with the consecutive company-related legislations providing itself an effective legal tool. Whether it's required amendments, modifications, etc., is up to the panel for discussion today. With that, may I humbly invite Palitha sir to enlighten us on the winding up procedure vis-a-vis the provisions of the Companies Act and the rules of 1939. Over to you, sir.
Thank you, Janaka. Good afternoon for everybody. There are all 30 participants already participated and registered. And of course, topic given to me for a 15 minutes talk is good for even 1 hour, 1.5 hours. Therefore, I try to restrict only for a few important provisions of the Companies Act and the winding up rules. As Janaka mentioned, our winding up regime is basically governed by 2 sets of laws. Mainly, principal enactment is Companies Act number 7 of 2007, and the procedure is governed by the winding up rules 1939. So in that, these rules were made in 1999. Even those rules are applicable under the present act. Of course, I know by personal experience, a lot of lawyers are aware of the Companies Act. At least they know there is something called Companies Act. But my day-to-day experience, what I understand when I observe in the proceedings, most of the lawyers, I think 90% lawyers in this country, they don't know anything about the winding up rules. And even they have not seen, they have not heard of it. And that's very unfortunate situation. And it was drafted in 1939 colonial period, but still even today we apply some. And having said that, basically we have to start with the section 267 of the Companies Act, present Companies Act. According to section 267, there are 3 types of winding up. Firstly, by courts. And winding up by the courts are dealt in section 270 to 280. Then voluntary wind up, dealing with the section 319 to 341. Then subject to supervision of the court by a resolution of the company, dealing with section 351 to 355. So those are the main enactments dealing with the winding up, commencement of winding up. And under the present act, that's Act number 2007, 7 of 2007, the Commercial High Court has an exclusive all-island jurisdiction in respect of all winding up matters. Previously, under the Companies Act number 1982 Companies Act, the court, district court, where the company is having a registered office, had jurisdiction over the winding up matters. Now, after new act, all brought in the Commercial High Court, so all matters are dealt in the Commercial High Court. And then who will be the parties to the who are entitled to present a petition for a winding up? Section 272 deals with this matter. And either a company or by a creditor or creditors or contributory or contributories, or all by all or any of those parties jointly or separately can bring in an application to wind up a company. So even the company on its own can bring the application, or even the creditor can bring the application. Even the creditor and the contributor, there's a shareholder, or a different version, contributor, they can jointly bring a application for a winding up. Then what grounds you can ask for a winding up? And these grounds are set out in section 270 of the Companies Act. Now, according to 270, the company can be wound up by a special resolution adopted by the court, by the company. Secondly, the company does not commence its business within 1 year from its incorporation or suspend its business for 1 year. So if the business is not commenced within 1 year, the party can bring in the winding up application. And there's a reported judgment, TCI Hotels Lanka Limited versus Marina Corporation, reported in 2002 SLR, where TCI Hotel wanted to have Hotel Sheraton at the Colombo. They couldn't start the business due to the political and terrorism-related matters. Therefore, the party made application to wind up the company. Then thirdly, if the number of members falls below the minimum number required under section 2, subsection 2 of section 4, then there can be application to wind up the company. Fourthly, if the company has no directors, then that's also ground to wind up a company. But the most common thing is on the ground that the company is unable to pay its debt. So I will come to that later. That's a very broad, and practically 90%, 99% cases are on that ground. Then lastly, there is a provision to say that the court is of opinion that it is just and equitable that the company should be wound up. Normally, when you plead any other grounds, we plead the last. This is also as one of the grounds to get the discretion reliefs under the Companies Act. Say, for instance, main ground is a company's inability to pay the debt, but of course, we plead this is just and equitable to wind up the company. Now, so those are the grounds to wind up a company by the or through the court or by the order of the court. Then under section 200, we take one of these grounds in detail, and especially I think we have no time to deal with all matters. And the important thing is the inability to pay debt is the most common and ground for a liquidation or a winding up matter. Normally, all of these cases, petitioners relying on the section 271 of the Companies Act, where the creditor can give a statutory notice to the company to pay up the debt. Now, important thing is the company, this section 271 commences with very important words. It says, a company shall be deemed to unable to pay its debt, where then it gives a three separate grounds. So you can note the wordings there. A company shall be deemed to unable to pay its debt. When you know that as a lawyer, when you say deem, it's a legal fiction. It's a legal fiction. So the law statute can say everyone born after 1st of January 2022 shall be deemed to be a male. So even the female is born, the law says that person is known as a male. So that is how we bring the legal fiction into the law. So these are some sort of irrebuttable presumptions. But of course, under the company law, when you say it's a deeming provision, you have to comply with the 3 other grounds. One is that a creditor can give notice, 3 weeks notice, leaving the notice at the registered office of the company and demanding the payment. Then in that ground, if the payment is not made satisfaction to the creditor. That's one of the grounds. Then second ground is execution process of a judgment, decree or any other court in favor of creditor or a company is returned unsatisfied. So decree's judgment is there, it's not, money is not paid, decree stands unsatisfied. That's also ground. Then there's a third ground. It is proved to satisfaction of the court that the company is unable to pay its debt. And in determination whether company is unable to pay, the company shall take into account the contingent and prospective liabilities of the company. So the first usage shall be deemed. Then there are three grounds. Of course, third ground is court can take the notice and on the facts and circumstances that the company is unable to pay the debt. So always when we in the winding up application, when we rely on the 271 statutory demand and the legal fiction, we also try to adduce the evidence to show that the company is unable to pay its debt on the facts and circumstances. And that's very important for a practitioner. Don't rely on the statutory, only the statutory demand. And even in England, statutory demand is there. In the England legal code of legal regime, when the statutory demand is given, the company can go to court and make the application that they are not liable to make the payment. So there is another procedure to follow. But in our country, we don't have that procedure. And therefore, whether you can pay the money or not, you cannot pay the money, is tested in the winding up proceedings. By the time, I'll refer later, notice has been published, it is gazetted, notice has gone to the banks, they will not lend you any money, the creditors, other creditors will rush into court, even the money is not really technically due and payable as at that day, they will demand that money. So all the creditors will be there trying to get the money. So there will be a lot of chaos. And so that's why some of the litigants, they go to winding up to blackmail and what you say is twist the arm of the debtor and more than the for a real winding up the case. And of course, we must say, I think some other speaker will look after, winding up is not the alternate method for recovery of debt. But again, I think I have to mention at this stage, disputed debts. Disputed debts. And the dispute should be in bona fide, is not a ground for a winding up. So what is the debt, or whether it's a dispute is bona fide, again, this matter for the court. Sometimes when they admit the claim and will say, yes, we'll pay, when the statutory demand is sent, immediately says, no, this debt is disputed. This money is not due and payable. So in that case, court will look into the matters, facts and circumstances, will decide whether this dispute is bona fide or just a method to prevent the creditor from taking the advantage of Section 271. Of course, there are as say there's a winding up matters, there are a lot of laws covered by this and a lot of judgments. And in the case of whether the company is in debt, unable to pay, court will take into consideration of the wishes of the majority of the creditors. If the majority of the creditors says, no, this company is good, it can go ahead, though the large sum of money is due and payable to the creditors. Court will take in that matter into consideration, will not allow the winding up. And there are similar circumstances, court will look into the matter and facts and circumstances and decide as a matter of discussion whether winding up should be allowed or not. And I mentioned that earlier also, the just and equitable, we treat this as an alternate ground. Of course, under the Companies Act, under different provisions, under the operations and the mismanagement. And one of the grounds is, yes, you cannot remedy the operation or mismanagement. And then it's a just and equitable to wind up the company. Then winding up by the voluntary by resolutions. Under section 390, the company must adopt the resolution, special resolution, and the resolution must be gazetted, and that procedure is there. Thereafter, if the company fail to adopt the resolution or gazette, there are penal consequences and similar thing. Of course, even they having adopted the resolution for a liquidation by the company itself, the company can come before the court, ask for a winding up subject to supervision of the court. In that case, the court will take over the liquidation proceedings. From that point onwards, appoint a liquidator and take the best other things through the other dealing with other part of the winding up under the winding up rules and the ranking, collection of assets and liabilities, reporting, all those matters. And so then when you start the winding up rule, important thing is commencement of winding up. Once the petition is presented, unfortunately, our law is the commencement of the winding up. So when the initial just the papers was presented, filed, then winding up legally started. So when the winding up matter is pending before the order is made, there are certain consequences. Creditor or the party can, when there's action against the company, the action can be laid by, may laid by, not the shall laid by, so may laid by. And also, once the winding up order is made, that operative date of the winding up will date back to the date of the either a date of petition or in voluntary winding up, the date of the resolution. And most transactions, alienations of properties, assets, change of shareholders after the date of petition or after date of resolution shall automatically be void. So we have to be very careful when the winding up matter is pending before the court. We must not go and try to purchase that property or sell that property or involve in the transaction. Because if winding up allowed even after 10 years, the whole transaction will be void. So we have to be careful about that as a practitioners. We have to advise our clients, be careful on this dealing with the properties of the company while the winding up matter is pending. And of course, all this time I have spoken to about the main procedure, but the important things are winding up rules. Winding up rules I have mentioned made in 1939, but it's a completely different procedure. It's not a civil procedure code. And filing a plain, there's a form given. And in the form, what are the essential ingredients in the application for winding up also given. So you have to very simple, take the winding up the rules. It's in the substitute legislature of 1956. And if otherwise, you have to take a photocopy. Its printed version is not available. So we have to take a printout photocopy from the substitute legislature and have a set of winding up. Then that petition must be present. Then once the petition is filed, within 4 days of filing the petition, you have to present what we call verification affidavit. And the form for the verification affidavit also given in winding up rules. And it's a short affidavit, only one paragraph. In short, it says what contains in the petition is true, and I affirm to that. And of course, recently, the Supreme Court and Court of Appeal also adopted this same procedure of giving the one paragraph short affidavit in the Court of Appeal Supreme Court applications. That shows, see, our whatever thing, 1939, our legislature talked about the short affidavit and cut short the proceedings. After almost about the 90 years, we are now adopting it for other proceedings. And once the affidavit is filed, of course, there is no requirement to support the application in the open court to satisfy the satisfy the judge. But it has become a practice to make the application in the open court and satisfy the court that there's a good ground, prima facie case for a winding up. Then only the court will fix the matter for a winding up and order the party to make the publications. So publications must be made in all 3 languages now in the daily newspapers, in addition to the government gazette. That publications is very important. Publications inform the public and the matter is pending in the court. If you have any claim, inform the instructing attorney or the petitioner your claim and inform whether you intend to appear and whether you intend to support or oppose the application. And that's a requirement under the rules. Then only you can go to court and say, yes, I'll appear for the so-and-so creditor and so-and-so contributor and make a claim, say this is my claim, and say I'll support this application or oppose this application. Then lastly, you have to, of course, a registered attorney must file the form 13 under form. You have to give these are the creditors supporting, these are the people are opposing. So thereafter, court will take the matter for inquiry, and like a normal inquiry, most of the cases are disposed by affidavit and the submissions. Of course, in National Bank versus Colombo Commercial, it was decided that in the FIT case, the court can grant the opportunity to part to lead oral evidence. And so there is no rule that you cannot lead oral evidence. In the FIT case, you can even lead the oral evidence. So court will take into consideration and ultimately make the order to wind up the company. Of course, my understanding, my view is winding up order is only an interlocutory order. It's not the final order. It's not the final order. I want to insist on the final, saying it's not a final order. I don't think there's a right of appeal against that order. Of course, on the previous Companies Act, there's a right given to make the application appeal, but in the present act, again, that right is not there. So there is a gray area whether the application for any order against the winding up, whether it's a leave to appeal or final appeal. So that issue is there. So we have to be careful about that. I say it's an interlocutory order because irrespective of the winding up order, the proceedings will continue. The court will appoint a liquidator or a provisional liquidator or liquidator, and the liquidator will publish the notices, call for a creditors meetings, collect the assets and pay the liabilities. So that process will go irrespective of the appeal. So therefore, it looks like it's an interlocutory order. So I have taken, I think, more than the time given to me. Sorry, I have to cut short my presentation. Of course, in the question and answer session, if I am prepared, I am ready to answer any relevant questions on the procedure. Thank you very much. And I am sorry for taking more than the allocated time. Thank you.
Thank you very much, sir. That was quite an insightful session, and we thoroughly enjoyed that for summing up all the relevant provisions of the law in relation to winding up. Dear participants, next we have a very versatile lawyer, Mr. Avindra Rodrigo, President's Counsel, who has a wealth of knowledge and experience in the field of winding up and the internal processes as to determination of solvency of a company so to be wound up and incidental matters. Today, Mr. Rodrigo will share with us what solvency test is all about and the prerequisites for a winding up application. After having done away with the capital maintenance rule under the previous Companies Act regime, the present Companies Act sets out the novel yardstick or criterion to determine the financial healthiness of a company, capital maintenance, how secured creditors or contributories are, and so on and so forth, by introducing the concept called solvency test. Along with the solvency test, there are certain other ingredients that constitutes a proper winding up application before court. That said, Mr. Avindra Rodrigo, President's Counsel, will lead us through the concept of solvency test and the prerequisites for a winding up application. Over to you, sir.
Thank you, Janaka. I presume you can hear me.
Yes, we can.
As the discussion is on winding up, I will first deal with the matters of winding up and then get to the solvency test. And for us to understand the concept of winding up, and that dovetails into the solvency test also, we need to first see where the company begins, which is what we have called, at least for this presentation, the birth of a company. All right. So if I can have that slide now. Yeah, the Janaka, the slide sharing has been disabled. Can I have the slides sharing enabled, please?
Yes.
Post Bar Association.
Yeah, the Bar Association will take up that.
Yeah.
Can you enable the screen sharing option, please? Yes, I think it's on now.
Okay, so I have taken the liberty of titling this "Live and Let Die" because we are talking about the life, the birth, the life, and the death of a company. At least the life and the death are important for this discussion. And if you look at that, the stakeholders who are participant and then come into place during the life of the company or the birth of the company are relevant. So let's look at this first very quickly. Why do people get together to corporatize? All right. So the point is that they want to have their interest in cooperating in a joint venture. And so you have a bunch of people getting together to form a company so that they can have a common venture together. And as a result, you have several stakeholders that are created. The stakeholders begin with the members who have advanced the capital. You have the creditors who will lend to the company. And then you have the management and employees who engage in creating goodwill and business for the company. And of course, you have service providers and other lenders who are all stakeholders of a company. If we go from there to the next slide, which is what happens when there is disputes arising between these stakeholders and the company or between the stakeholders themselves. So if you have disputes between shareholders, that is those who have got together to form the company, they can try to have that remedied by filing, for instance, an oppression and mismanagement suit. And if that fails and the matter is not resolved there, what would then happen is that the company ought to be put into liquidation. And the side note you might want to remember that once upon a time, if shareholders could not get on, the only way that the matter could be resolved was to close the company down. So if you get together and you can't continue the marriage, you have to terminate it. All right. So that was the idea. And that's what we get in a winding up by shareholders, usually where they either see the business not continuing or they can't get on with each other. Mr. Kumarasinghe mentioned the just and equitable criteria in the Companies Act, and that would encompass this sort of situation. That is where a group of shareholders cannot continue operations or get together and continue the company together. Then you have the creditors who find that they are not being paid the debt that has become due. Again, as Mr. Kumarasinghe pointed out, there is deeming provisions in the Act. And if there is a non-settlement of a debt and the provisions are spelled out in the Act, a creditor is entitled to apply to court to wind up the company. So these are the very stakeholders who participate in the incorporation and the continuance of the company are those who will eventually petition to wind up the company. Now, if you look at the grounds under which you can have a winding up, the three broad categories are winding up by court, which is the matters that we went through earlier with Mr. Kumar Singh. Then you have voluntary winding up, as well as winding up subject to the supervision of court. Let me just talk first about, very briefly, about the voluntary winding up. And the principal difference between a voluntary winding up and a winding up by court, apart from, is one is done by the members and in some instances the creditors themselves, and the court does not participate in that unless you move where there is some provision where if you think that the winding up will be better carried out under the supervision of court, you can have winding up under the supervision of court, which is some part, if you like, of the voluntary winding up proceedings. And the other important thing about the winding up proceedings that are voluntary is that it can only be gone into or embarked upon if the directors are able to say that the company is solvent. That is, and there the solvency test that we talked about, we will have to, which we are going to talk about, is different to what is contemplated in this section. It's not a happy situation that the Act has two mentions of solvency which don't appear to be strictly related, but we'll come back to that. But anyhow, looking at it as it is only if that the company can be declared solvent, that is, where the directors can say that the company is solvent, that you can move to a voluntary winding up. If we look at now the winding up by court, which is the item on the left-hand side of the screen, this is what is also had, well, voluntary winding ups are also had there is a lot of recourse to that. But suppose you come into a situation where the directors cannot put that declaration of solvency, then you would go into what is called a winding up by court. So here, why the court must intervene is that the creditors must be protected, okay? Because there isn't enough to go around. In a voluntary winding up, there is enough to go around. But that's why there is a declaration of solvency there. And then you go into, if there isn't enough, you go into what is called a winding up by court. And there I have given broadly the items. I don't want to go into that because Mr. Kumar Singh also covered that, okay? And now if we go next into the solvency test, although it is important that we look at the solvency test in the context of winding up, it is also important to realize that there is no link between the solvency test and an application to wind up that is made to court. All right, so you might be surprised at this, but the solvency test is something that was introduced, as Mr. Basuri has said, later in the more recent legislations in other countries, as well as in Sri Lanka only by the latest act. It didn't exist before. Now, the solvency test is a restriction. I would best describe it as a restriction on transactions that may render the company insolvent. That is to say that if a company is about to embark on some specified transactions, and I have put that down at the bottom here, such as a distribution to shareholders. Okay, so assume that the shareholders decide themselves to make a huge payout to themselves by way of a dividend. Now, if that is going to happen, and that after that distribution, you end up in a situation where the company fails the solvency test, then that is obviously something that the company should not embark upon. All right, I hope you are following me on this. This is, yes, it is not obviously advisable for the shareholders to take all the money out of a company and leave the creditors and the other stakeholders, including employees also, with nothing there. So we have now section 57, which says that before you do something like a distribution, or if you try to reduce capital, or you give financial assistance to acquire your own shares, those types of transactions, you must first ensure that after that, these two limbs that I have put down here are met. Okay, those two criteria must be met after. So you must plan that out, calculate that beforehand, and then if you're going to fail those, you don't do it. Okay, so the first is that the company is able to pay its debts as they become due in the normal course of business. Now, this is differently worded to the winding up section. I don't want to confuse you, but the winding up section 271C does not say as they become due, and it does not say in the normal course of business. So this is a new addition to the other set of words, the company is able to pay its debts, which has come in with section 57. Okay, so this contemplates more, it's not dealing with assets, this contemplates more a liquidity position. That is, as and when the debts become due, can the company pay? So it is no point saying, I can pay in 10 years or 5 years or even 6 months. You should be able to pay it as and when they become due. So here, there is some kind of analogy or parallel to the winding up provisions, because we are covering both of these in this discussion, because in the winding up provisions talk about the company and being unable to pay its debts. So obviously there is that connection, and that means then that if you are going to embark on a transaction which is going to have the result of the company being unable to pay its debts as and when they fall due, or even if you stop at companies unable to pay its debts as the winding up provisions provide for, then you shouldn't do that, because if this kicks in, technically, you must move to wind up the company, if you are following what I'm saying, okay? So it's a prohibition, and if you do that, you're saying, okay, you must now wind up the company also, because you're echoing what is there in the winding up rules. Then on the right side is a further test that you must pass before doing a distribution. I know there was a case fairly recently where the directors and shareholders, it was virtually a family-owned company, and they paid out to themselves huge dividends, and then after that moved to wind up the company, to leave the creditors obviously in the lurch. That matter went to court, but that payout then was clearly violative of section 57 of the Companies Act. That is, the company, after paying that distribution, failed the solvency test, which meant that that distribution should not have occurred. Now, if you look at what the right side of your screen says, we are now looking at the assets. We looked at the cash flow, now we are looking at the assets. And the way that works is that the value of the company's assets are greater than the value of its liabilities and the company's stated capital. Now here what we are looking at is what is available for distribution to both the shareholders and the creditors. So the value of the liabilities is broadly what the company owes to its creditors. The company's stated capital is broadly what the company owes to its shareholders. Okay, so if you take those two together, you must ensure that those two numbers are greater. Sorry, the value of the company's assets in total are greater than those two numbers added together. All right, I will repeat that. You have to take the entire value of the company's assets. Suppose it is 100, and then you add up what the liabilities and the stated capital are, and you match the two. And if the assets are in fact greater than the addition of the other two items, then you can proceed to make the distribution. If it's not, then it is prohibited. All right. Now, we have talked about the formalities to proceed to wind up and so on. And as Mr. Kumar Singh has said, it is a method of twisting an arm to force payment most often. But if you take the solvency test, okay, go back to the solvency test. If you go back to the solvency test and you take that in the context of winding up, you can see that the objective here is to protect the creditors and to protect the shareholders themselves. So, for instance, if there is one group of shareholders who are trying to profit unreasonably, they may make a distribution or reduce share capital or even give financial assistance in a wrong way, so that you end up diminishing what is there to give back to the shareholders. And similarly, of course, by doing it even all together, if the shareholders are together and do something like that, they would be prejudicing the creditors. So this check technically should prevent a company from going into specific transactions that would result in the company being in a situation where it ought to be wound up. All right, but it does not protect against a company gradually sliding into winding up. Okay, let me clarify that. So if you are trying to make a distribution and you do that distribution, then, as I said, according to the two limbs of 57, the company should be wound up. If you go ahead and do it despite the prohibition in section 57. Now, if everybody follows 57, technically, you shouldn't do any such distribution which will result in the company being unable to pay its debts. All right, but that is to do with specific transactions. Now, if you look at winding up as a whole and winding up where the company can't meet its debts, that can happen not only by way of a distribution, it can happen because the company becomes non-profitable and gradually slides into decline. So section 219 of the Companies Act also is worthy of mention, because the solvency test applies there, and what it broadly says is that where the company fails the solvency test, or to realize that it has failed the solvency test, and this is not linked to a specific transaction. If you apply the solvency test to a company today and you find that it has failed the solvency test, then you have to go in. That is the first limb of the solvency test, I should say. That is where it can't meet its debts as and when they fall due. Then there's a obligation on the directors to move to have the company wound up. And this is a really salutary provision. If they continue to operate the company without winding it up, then they become personally liable for that interim period. Okay, so I want to just finish this by saying that often people are very reluctant to close down companies, but as I said in an earlier presentation in another event, there is a time to live and a time to die. And as far as a company is concerned, we have to let them live and also let them die where they ought to die. And this bit is taken from the Live and Let Die movie, but I couldn't broadcast most of it because of obvious copyright issues, and it would be appropriate, especially in the BASL webinar. Thank you. Yes.
Thank you very much, sir, for that. We must let them live and let them die also when the same during its period. Ladies and gentlemen, next we have Mr. Hirandi Alvis, who himself is an expert in the field of winding up and liquidation process, and he's an experienced commercial counsel. Mr. De Alvis will share with us his views on some practical issues relating to winding up of companies by court and the effects of rules, with a special emphasis on post-winding up order scenario, like provisions relating to collection of assets, ranking, consequences of winding up, etc. At this point, I must mention that the role of a liquidator in a winding up process is of paramount importance, and we should have a separate webinar to discuss these matters incidental to a role of a liquidator. So it's not the forum today, as we may not have enough time or patience to discuss all of that. With that, may I now invite Mr. De Alvis to talk about some practical issues relating to winding up of companies. Over to you, sir.
Thank you, Janaka. Good evening to all. As I stated at the start, we have to, in keeping with the topic, wind up this session at 7 because there's important engagement. So I will make it a T20 innings. And just in relation to this topic, so I don't want to traverse the same area which the Learned President's Council has spoken earlier, but you should know that this provision for winding up of a company is statutorily recognized in Sri Lanka. So the reasoning behind this, if I may, relates to a limited liability company when it was given statutory recognition. In my view, this is one of the great innovations of the legal system, where the law evolved and conceived this notion, giving limited liability to a business entity. So this enables people to take risks, do business, generate profits, create employment, and all that. So this dramatic growth in economic growth was enabled by, in fact, a legal fiction, the limited liability company. So conversely, there is also a legal right to legitimately close down a company and a business. Then you are able to distribute the assets and settle the claims. So that's why it has been given statutory recognition, and it is a salutary provision which allows parties to take risks and start a business and close down also in accordance with the law. Now, various methods are recognized worldwide, and statutory recognition, as I said, in our Act, and as mentioned earlier, in the winding up rules. Now, may I briefly refer to a few points how it came into being. These winding up rules actually, though it came in the World Courts Ordinance, and it has came then to the 1982 Act, and now obviously to the 2007 Act. And the background to this, as you know, comes from the old English law. And in relation to our interpretation, we also look to the English law, But it would also be interesting to see when we are traversing those authorities that after one point, when England joined the European Union and where the interpretation has changed, now again, possibly in the future, with the decoupling with the European Union, we may go back to the original British interpretation models. But in line with using these foreign judgments also, I believe we should express caution where we look at how they approach in the European civil law jurisdiction approach and the British approach. Also, in terms of the rules, I think, in my opinion, even after so many years, it has been a salutary provision. There are over 500 pages there. It shows, like the evidence ordinance, how far-reaching and far thought of piece of legislation. This is the only recourse even now for us practitioners is the winding up rules. Now, as you said earlier, winding up by courts or voluntary. I will refer to winding up provisions by court. Voluntary, as set out earlier, only two methods: when the company is solvent by the shareholders, or if there's a creditors winding up, when the company is unable to pay the debts. Now, winding up by court, section 270 of the Companies Act, there are subsections A to F. I'm not going to traverse the entirety of the area. Our learned panelists, I'm sure, will have recourse to that. So there are few points there which brings into the areas where you can wind up. What is important to note in all these is, if there is a bona fide dispute, there cannot be a winding up. So when you are using this methodology, if there is in fact a risk of a bona fide dispute as to the debt, you are running a risk of the winding up process stalling. Now, also, if there is a genuine dispute or a debt, court can dismiss it or stay the application. There was recently also a Sri Lankan case in the Commercial High Court, where in fact the court dismissed a winding up case at the threshold stage. Also, there are some British authorities, 1874 case, which refers to giving the power, and a salutary case, 1964 3 AER, which upheld the provision that if petition is for extraneous purpose or improper purpose, court can intervene and stop the process. Then also the question arises whether court can grant an injunction if the action is deemed to be in the nature of a blackmailing action, and where the parties are inveigled into a settlement through the threat of adverse publicity. This is a felt reality of the times, as most of you know. A recourse to a Sri Lankan case, Senaviratna versus Senaviratna, possibly 1982, refers to the possibility of court granting such injunction. I would also refer to a All England report case, 1963 2 AER. I just read the head note for us to get an inkling of the thinking behind this. So 1963 2 AER, page 940, Charles Fort Investments, where the court held the presentation of a winding up petition would be restrained by an injunction granted under the inherent jurisdiction of court to stay proceedings which were vexatious or an abuse of the process of court for following reasons which set out. Then in that case, it also held that an object of the jurisdiction was to restrain the assertion of doubtful rights in a manner productive of irreparable damage. So clearly, there is authority for the fact that the court to grant interim injunctions stopping a vexatious claim. this principle, I believe, also upheld in a 1968 2 AER case 769, Mann versus Goldsmith, and in a 1973 3 AER page 769 case, Euro Hotel. So you can say the English authorities, which are of very persuasive value in relation to the winding up actions, very clearly has upheld the position that interim injunctions or interim relief can be utilized to stop these blackmailing sort of actions. Now, our Act also in section 273, 274 permits interim orders to be made. So there is statutory recognition. So before a winding up order is made, any creditor, contributory, may apply for a stay or restraint of any action pending against the company in any court in Sri Lanka. Then application can be made to either the winding up court or the court where another action is proceeding. So I believe the whole idea is to protect the dignity of the winding up process and the parity of creditors. So as I said, a very well thought of statutory provision is there in the law. Also, section 302, court may stay proceedings on application of the liquidator, creditor, or contributory. Now, one or two practical areas which possibly we can give our mind to, or maybe the Bar Association and its expert committees, is this definition of inability to pay debts. So when it's for a limited amount of rupees 50,000, whether you can go to courts and it's whether fair to wind up a company. So to consider whether this minimum amount in the present days of inflation should be increased, where otherwise it deems to be a joke. Another issue which I would want to bring your attention to, and maybe we should give our mind to, is whether ex parte applications to court and the resulting advertisement of the notices should be permitted. Because this is the loophole where abuse happens. For example, as you know, winding up rules states, Rule 7, every petition shall be advertised 7 clear days before the hearing, once in the Gazette, once at least in one daily English newspaper or whatever published. So this is mandatory. Now the question arises, if you make this ex parte application, it is a matter of course where it comes in the papers. It is mandatory. Apart from the danger of this being abused, with the present development of electronic transactions, it is also arguable that the newspaper, in fact, can be an electronic newspaper. So, in fact, the publication will not only be in the Gazette, it will be in an actual physical newspaper. It can be in a go right around the world that, in fact, there is a company that has been a winding up process has been initiated only. This can have dramatic effects, especially for companies engaged in international trade. Then in relation to, may I say, these ex parte applications, the question is once this is deemed to be the presenting of the action or the beginning of the action, whether the court can at that point intervene and stop the process. So I believe the whole process has to be looked at realistically in the context of the present socio-economic realities of Sri Lanka, where advertisements of winding up in the newspapers can cause grave damage to a struggling company, especially in the present situation. So I believe this whole process of advertising of the petition ex parte should be looked at it very, very carefully. Then I dwelled on the availability of the interim reliefs. The other question which I would be also giving my mind to is whether in fact damages is an adequate remedy. If there is a false winding up case and you can file a malicious prosecution, etc., but the damage done by a frivolous application for winding up and a publication in court, and whether irreparable loss and damage will happen, whether in fact damages case, which can even take 2 years, would be in fact nugatory. So it is time to look at this provision. May I also refer to Mr. Janaka Basurya referred to this provisional liquidator's role that very briefly comes up in section 286 of the Companies Act. So that comes in vis-a-vis the normal liquidator being appointed as a provisional measure, especially as there's a risk with leaving the company in the hands of the directors pending the whole process going on. As somebody, one of the speakers mentioned, somebody, if they were paying the dividends or payments to themselves, this can in fact easily be done even in the pending process. So in conclusion, I can refer to a Sri Lankan case. Colombo Engineering Enterprises was an HNB, where court held winding up procedure is not a means of debt collecting, nor is it a means of bringing undue pressure on a company. So in keeping in with that, we should, I believe, safeguard the original statutory recognition given to start a company by the statutory incorporation of company and properly wind up a company in terms of the statutory procedure established by the Companies Act. Thank you, Jonathan.
Thank you, sir. Thank you very much for number of interesting takeaways from your session. I personally like that idea of having maintaining a minimum amount to apply for a winding up application. I think the legislators will take heed on these kind of propositions. So with that, ladies and gentlemen, our last batsman for tonight, ladies and gentlemen, is Mr. Lakshmanan Jayakumar, attorney at law, a vibrant counsel who hails from Dr. Carnegie Insurance Chamber. He's well versed in the area of winding up and other commercial matters filed before the commercial high courts and other fora. I know he's he's keen on commercial arbitration as well. Mr. Jayakumar will address us on the topic of winding up is not a recovery tool, an analysis of the purpose of winding up, taking into consideration the recent developments which is taking place as of today. Without much ado, let me invite Mr. Lakshmanan Jayakumar to address the participants. Over to you.
Thank you, Janaka. Yeah, sorry, I was muted for a moment. As the tail ender, I don't think I will last very long as usual.
Legends.
So, as most of the speakers before me, especially Mr. Rialvis, had spoken on this arm twisting of a company to recover debts is of course a perennial problem in the winding up process. The fundamental premise that is often overlooked in winding up matters is that the winding up court is not there to resolve a debt dispute. That's often overlooked. The winding up court, if we can call it that, though most of these things end up in the commercial high court, even if it's other matters, is not there to assess whether the debt is in fact due to the company. All those things are a different species of litigation. The winding up court is there simply to see whether the company is, if we can call it in easy terms, a viable concern. can it keep going on, or has it come to, like Mr. Rodrigo said, has it come to its natural death, or it's on the throes of death? Do you need to pull the plug on it? So in reality, we are all, I suppose, speaking for me, we are in a sense culpable for this as well, is that the winding up process is often used to arm twist, to recover debts, especially like Mr. Dialbi said, the publication in the newspapers and the Gazette and all those things is a terrible advertisement to the world that you're about to go under. And like I believe Mr. Kumar Singh has said, the banks will stop giving you any more facilities. Your other creditors will stop giving you credit. And what happens is that even a company that was, shall we say, managing to keep his head above water will go under. That's the sad reality of a improper winding up application. I believe that while the winding up process is in fact a necessary aspect of corporate life, because it seeks to put an end to the company at a certain point, if in fact the company can't live a useful life beyond that point. Like Mr. Rodrigo said, a lot of times there is this sentimental attachment to keep the company going, whatever the cost. And at the end of the day, it gets deeper and deeper and deeper into debt and issues. And more creditors are prejudiced. So that is why winding up is there. But at the same time, this misuse of the provisions is a real and present danger. So the only question, my perspective on that is that while we must be mindful of that, the winding up provisions need to be had, more adequate safeguards need to be imposed, especially on this 50,000 in today's time and context might seem a low figure. And maybe the way forward would be like to have the amount maybe varied by gazette. Maybe the act needs to be amended to say that the limit on a statutory demand would be something that the Minister of Justice or whoever will gazette, so that you're not dependent on enactments being passed in Parliament, which we all know take a long time, often don't see the light of day till a long time passes, and by the time the enactment comes, we have again been overtaken by events. So they make it 100,000, and then before 100,000 doesn't count for anything. So maybe an amendment to that effect could be a possible way to circumvent this. As far as these debts are due, quickly just to recap, I will not labor on it. There is the notion of a commercial insolvency, which is the fact that the company is unable to pay debts as it falls due, irrespective of having a large asset base, which could satisfy all its liabilities. But a creditor is not expected to wait till all these assets are realized to get his due from the company. So that is the aspect of whether a company is commercially insolvent. The other aspect is, of course, the fact that the assets are far outstripped by the liabilities. So at the end, there will be insufficient realization of, even if the assets are realized, there would be insufficient amounts to satisfy all the creditors. Coming back to the core theme of it being misused, I have, like Mr. Dialvi said, that this malicious prosecution is an option. It has happened. There are several other jurisdictions where it does happen. But I am yet to see anything. I am not aware of anything in Sri Lanka where anyone has, in fact, filed an action for damages, because, like Mr. Dialvi said, the time and cost factor incurred makes it maybe not a viable option. And also another possibility is that you wrongfully bring this winding up application, and then you, in that sense, kill the company. Then thereafter, there is nobody to take on this burden of challenging a wrongful winding up application. So these are all these aspects that are are present in a winding up process. But while you must allow companies to die a natural death, not unnecessarily keep them going and incurring even more liabilities and prejudicing even more creditors and other stakeholders in the long run, the misuse needs to stop. maybe the answer is in some sort of statutory enactment which limits the scope of a winding up, maybe some specific order for damages or something in the Companies Act which says that in the event of a improper winding up application, that punitive damages will be awarded, something that puts a higher threshold or a higher onus on any party seeking to wind up a company, because without that, often, like we've all agreed, is often a recovery tool, possibly the fastest recovery tool in most instances. But maybe it ought not to be. So as far as the practical considerations are concerned, we need to, I think, maybe have a mechanism by which this statutory demand figure can be adjusted depending on the circumstances without being dependent on legislation, and maybe a more robust safeguard in the Act itself, which limits or which will have the effect of limiting winding up applications. And if found to be an abusive or a misuse of the winding up provisions, maybe exemplary punitive damages must be awarded, so that a provision like this is not taken to arm twist and get people to cough up any money that they allege is due. So that's just keeping it very briefly, but it's a practical and real problem. Maybe it needs some legislative intervention to solve, but at the same time, it must be tested against the requirement that a genuine creditor must still be able to wind up the company if it's unable to pay its debts as they fall due. And like Mr. Kumarasinghe said, the deeming provision gives it legal fiction. So if that time lapses and you don't make the payment, it automatically starts. I believe certain jurisdictions, if a statutory demand is sent, you could in fact go to court and try to have the demand set aside. Maybe some aspect like that, where some procedure or some steps that you take will immediately countermand this statutory demand, so that will not then be the basis of a winding up application. So as an important tool in the corporate life of a company, it is essential, but like all good things, it can be misused for wrong purposes. And the idea is to strike that balance where the good is still available, but the misuse and abuse is prevented and visited with, I think, should be visited with punitive exemplary damages and costs. Thank you, Jonathan.
Thank you, Lakshman, for that those few ideas which are of value and of practical importance. Being a practitioner, thank you for sharing those views with us. With that, ladies and gentlemen, we now move on to our Q&A session. And also a small brief housekeeping message for all the participants. You may post whatever the questions that you want to ask from the panel in your chat box. You can use the chat box to ask any questions that you may want to ask from the panel. So my first question goes to Mr. Palitha Kumarasinghe, President's Counsel. So now, what is the effect of a voluntary winding up? Who makes such decisions, and under what circumstances? Now, voluntary winding up sounds like it's not supervised by or under the sanctions of court. Is it legal? What is the effect of a voluntary winding up resolution?
Yes, it's legal. There's a specific provision in the Companies Act, and starting from section 319 deals with the voluntary winding up, where company can adopt a special resolution and move for liquidate the company. Of course, there are other provisions like gazetting and give notice. So then they can appoint the liquidator and proceed with that. And as Mr. Arvind Rodrigo, President's Counsel, mentioned, of course, they can file a declaration regarding solvency under section 324. If the directors file a declaration that the company is not solvent, then that's a different matter. It's considered as again the company's resolution, if the directors has not filed the solvency declaration, then it's considered as a creditors voluntary winding up, and the rest of the thing can move on. Of course, after resolution, the company can make the application to court to take over the winding up procedure, and thereafter the court will take over, and court will appoint even the provisional liquidator or liquidator after the final order, and proceed as a voluntary liquidation under supervision of court. So, of course, that mechanism is the company adopt the procedure. They'll initiate without a judicial support. Of course, they can get the support from the court later. So that's the difference between the voluntary liquidation on its own and by the court. And that's permissible under starting from section 398.
Right, sir. Thank you. Thank you very much. So my next question goes to Ms. Avendra Rodrigo, President's Counsel. Sir, now, is failing the solvency test the end of a company? Does it mark the end of a company? Or should it be wound up for the simple reason that it has failed the solvency test?
Yeah. So the solvency test is not meant to be a method on which you decide whether or not the company should be wound up. Okay. So a solvency test is to preclude or prohibit some transactions which will put the company in a situation where actually it ought to be wound up under the first criteria of solvency, and also even the second criteria of solvency. So that is how the two work. If, of course, you, as I said, slide into a situation where the company is unable to pay its debts as and when they fall due, then you're also in a situation where the company has failed the solvency test, and under 270 of the winding up provisions in the Companies Act, you must wind up the company too. But they have to be looked at as two separate things. One is a prohibition, the other of transactions, the other is when the company ought to be wound up. So it can continue trading despite the solvency test having failed the solvency test. But on the other hand, we have section 219, which says that if a company continues to trade while being unable to pay its debts, the directors become personally liable. So it's complicated, but that's how the law is.
Absolutely, sir. Thank you. That solves doubts. So my next question goes to Mr. Hirandi Alves. Sir, would you be able to further explain a little bit? I know you touched upon this area in your presentation also, but who is a liquidator? And we come across this term provisional liquidator. What are the differences between these two roles, or is it one another? Is it the same?
Must be watching the match.
Sorry?
You must be watching the match now. You know.
Okay. Is he there with us?
Not on the.
Very well.
No,
let's move on.
There.
Okay.
Perhaps someone else can answer that question.
Yes.
Yes.
Would you take it up, sir?
Yes. Basically, provisional. What you call, we have an official receiver. Presently, Commercial High Court has got an official receiver, a person appointed by the court, and his function is to. But normally, he is appointed as a provisional liquidator, when you say provisional, that's appointment is made before the final winding up order is made. So in pending the application for a winding up, if you want a person by interim way or provisional way, then provisional liquidator is appointed. The first choice is the official receiver. Of course, you can get another competent person, qualified person under the Companies Act as a provisional liquidator. The liquidator is a person appointed after the winding up order, and he is the permanent liquidator, and he is in charge of the having the creditors meeting, collecting assets, and the distribution, ranking, everything. He is the person in charge. From time to time, he has to file the reports and inform the court this is the progress. And ultimately, he has to say, yes, I have distributed assets, and he can say declaration, this company has been finally wound up, and that's the liquidator. And difference is temporarily pending provisional liquidator. Once the order is made, the liquidator. Vinda, is that
very well? Thank you, sir.
Yeah, if I can just add there, two things. One is that most often it is a provisional liquidator who will be appointed as the permanent liquidator or the liquidator after the order. And the provisional liquidator would not be expected to start a sale of the assets and to start liquidating the company. He will be more protective and protecting the assets till if and when the final order for liquidation is made.
Can I state that provisional liquidator will maintain the status quo of the company after the application?
Yes,
more or less.
That's right. To maintain basically maintain the assets and of the company.
Marshal the directors don't whittle it away and
yes.
Yeah. Excellent. Thank you. Thank you. My next question goes to Mr. Jayakumar. Now, what are the other remedies available? Now, you said this winding up should not be a tool of recovery. But what are the other remedies available for a company who is opposing a winding up, especially in the context of a compromise or creditors meeting under Section 247 of the Companies Act?
So, okay, that's a different aspect of looking at it, Janaka, but it's often not, it's one of those overlooked sections often in today's corporate litigation, shall we say, in Sri Lanka. The first thing would be, of course, you would resist a winding up and go down that path, or the compromise with creditors, of course, is almost akin to the like a slightly protective. You come under the protective umbrella of court and use that to rearrange your affairs with the hope that the creditors will fall in line. So it is actually a very powerful tool that can be used to, if you are running through, shall we say, temporary stormy waters, it can give you some sort of protection against all these things. And that once you cross over that, those things are removed. An important aspect of that is that the creditors need to agree. Creditors or the class of creditors need to agree. So if you can marshal all the creditors together and they see that there is value in this company being a going concern, then you will have your meeting of creditors and put forward the compromise. And the good aspect of it is that if the majority of the creditors agree, then you could come to court and have those things as the arrangement by which the company goes forward. This is also a good tool, Janaka, for the aspect of things, because sometimes if you see most of these winding ups, as we all know, once the statutory claims and the ones at the very top are paid, the secured creditors are paid, most unsecured creditors are left holding the can, right? They hardly get anything, right? So if you don't, if you can, instead of that, if you have a system whereby all the creditors come in and agree, okay, we will reschedule our obligations or what is due to us by so much or so forth, and agree on a system, you might actually be able to keep the company going. But like Mr. Rodrigo said earlier, you have to be careful that you're not artificially extending the life of somebody who will not come out of this. You're just prolonging the inevitable and making things even more difficult in the long run. So if they have to die, they have to die. I mean, that's simply it. But it's a powerful tool. But I don't know, Mr. Rodrigo is probably the most innovative man in HAL
Yes.
stuff. I haven't done anything in under section 247, but it is something that I think maybe greater thought ought to be given to.
Yes, yes, if I can just come in there, it has actually been done. The idea is that you...
Yes, I'm also I'm a party to one of the cases, one compromise application.
Not to the end perhaps, but it has certainly been commenced. So the idea is that if 3/4 of the creditors and the company agree on a formula through which the company can continue to live, and that may or may not entail how they are going to get paid and so on, then you can't have the minority creditors or other people or thereafter coming and trying to block that. So it's going to extend the life of a company, but there is obviously a right of appeal from that. So as given in section 347 itself. So that's what it is meant to capture, where you keep going, where the creditors are basically deciding how the company should be run and also how their debts are going to get paid.
Just a small question there, would that be 3/4 on the number of creditors or on the size of your debt?
Sorry, I didn't.
3/4 of the number, sorry, the section says 3/4 of the number and value of the creditors. So you have to have both on your side. So if you have 10 members, you have to have 3/4 of that. Plus, you have to have in value, if it is 100 rupees, 75 rupees worth of creditors with you. Yeah.
So both limbs has to be satisfied.
Yes.
Thank you for that. If I may come back to Mr. Palitha Kumarasinghe, President's Counsel. Sir, now, what is the proper procedure to join in an ongoing winding up matter? Is it allowed? Can we get into the bus later on? Or what are the consequences of a belated application, of course, other than getting dismissed?
Of course, under the notice, you have to come to court. We have to give notice 7 days before. You have to disclose your claim. Then you have to say you are supporting or opposing. But now very frequently we see either creators or the contributors, they won't look at any of this notice. And even the major banks, they don't follow the procedure. They subsequently come and intervene under a normal procedure, making application, file petition, affidavit. We want to intervene the matter. There are several contested matters, but ultimately court follow the broad principle, right? If there's a party interest in the matter, let them come and make representation. And most of the time, court makes the discretionary order in favor of the parties sought to be intervened. And that's what happens practically. But legally, I think there is a bar. But of course, mere fact you have not come before the court does not prevent you from making the application or to make your claim to the liquidator. And liquidator will publish a notice asking for a claims. Then you can give your claim to liquidator, attend to the creditors meeting, and support your claim. So practically, if you want to be heard, you have to go to court. And if you are belated, at least make application by your petition affidavit and try to intervene in the court using the discretionary powers of the court. That's
right. Thank you, sir. Thank you for that. My next question goes to Mr. Rodrigo. Sir, what is the duty cast upon the directors in the event of a failed solvency? What can they do about it? Are they personally liable?
Yes, so the idea is, as I said, that they are not supposed to do it. If you're talking about failing the solvency test, is it? Or are you talking about where the company ought to be wound up and the company is still trading? So I'll cover both. So the solvency test is where they are not supposed to embark on a transaction like that. And if they do embark on a transaction which renders the company come into a situation where it fails the solvency test, there is an offense on the part of the directors. And on top of that, that transaction can be reversed. Yeah, right. All right, in some of the transactions. With regard to running a company when it ought to have been wound up, that is where it can't meet its debts, but it's continuing to run under 219, as I touched on earlier, for that interim period from the time that it ought to have been wound up and you ought to have moved to wind up and petition court, and the time that it is actually wound up. So the delay, the directors become personally responsible. We haven't, I don't think anyone has yet held the directors responsible that way and got money out of any directors, but this is a good threat that can be used to stop this. And as Mr. Jayakumar said, 50,000 rupees is not a lot of money, but we must also understand that a company has most often been set up to run and make money. So if it can't pay even a sum of 50,000 rupees, it should really not run any longer.
Right.
Yeah.
Precisely. Thank you for that. You want to add anything, sir?
Good logic. No, that's right. It's a good logic.
Right. So Mr. Hirandi Alvis is not there with us. I think he's enjoying his cricket match. My next question goes to Lakshmanan. Mr. Lakshmanan, now, can an unsecured creditor in any way succeed a winding up application? Or, I mean, the popular thinking is that their claims are overlooked most of the time. What is your opinion on that?
He can succeed, Janaka. I mean, as long as if the winding up order is made, which we think is the natural end that we are looking at, he can succeed. But the issue is, of course, that he stands so far down the line that the question of what he will get out of it is a thing. But when you are an unsecured creditor, you're deemed to know to take that risk. That is why you didn't secure your credit that you gave the company against some sort of a security. So you can succeed, but in reality, it might not be the most most profitable success. You will be left to get what is available once the others get their due.
Right. Thank you. So one final question. I think it's a bonus question for all the panelists in general. I need all of you to contribute to this. What is meant by ranking of creditors? I mean, this is a vast area, but just for our young practitioners to understand why ranking is necessary and what is meant by ranking of creditors.
Can I say that? Right.
Basically, yes, please.
Ranking, of course, everything, there must be a preference or merit list, right? It may be a selection, it will be Supreme Court judges, there's a merit C-note list. So like liquidation, there's a list, that list, and there's a particular order arranged by the statute. And so we'll find the secured creditors, then we'll find the unsecured creditors. And more than that, there's a 9th schedule giving the preferential schedule, preferential treatment for a certain creditors. So when you fall in, you have to check who are the secured creditors. If the secured creditors has a charge over property, according to present act, my contention is that property has been basically taken out from the assets of the winding up. though it's a liquidator can take the control, but practically that property will be taken out and it will be exclusively given to the secured creditor. If there is an excess only, that will come to the liquidator. And unless the secured creditor can surrender his rights and agree to fall in line with the other creditors pari passu, unless that the secured creditor's property will be outside the liquidation process. Then in the preferential list, you get the statutory dates, income tax, EPF and ETF and all those things. And ultimately at the bottom only, normal secured creditor is there. So the ranking is very important. Normally unsecured creditor, unless it's an asset-rich company, I don't think it will get anything in the way things are going. Most of the cases, bank jumps and take the mortgage property and they go for parate, they take the properties out. Then the rest of the thing, the statutory debtors, EPF, EPF, gratuity, they'll come and take over. So balance is for other people, pari and passu. So very important for liquidation, you get fruits come from the ultimately from the ranking, but you may get only rotten fruits at the end of the proceedings. Yes, Avinda.
Yes, I quite agree with that. As you will see, if it's a very long list, you can look at that, all of you who are listening. But the liquidator comes on top. So most often the person who, if you can call him a unsecured creditor, that will be, he's not, but it is a liquidator who benefits most from a winding up. Then the person who applied to court, his expenses also, gets off the top of the pile. And it is only after that, then of course, a taxman comes. And right at the bottom, you get the shareholders, and just before that, the unsecured creditors. And as Mr. Kumar Singh pointed out, the section 365 deals with secured creditors, and he's given an election of whether he wants to stay in the liquidation. Sorry, section 358, where he can stay in the liquidation, in which case he has to give up his security, very unlikely situation for him to do, or he can go ahead and enforce his security because now the company is being wound up, so he goes into his parate or whatever. So now I must mention here, when we're talking about it's a long list of preferential creditors, but what happens in practice can be quite different. When I can give you an amusing example was when garment factory was being wound up, and here we are talking about who comes first, whether it's the income tax man or the secured creditor, the unsecured creditor. The employees decided that this company is being wound up, and each of them took a juki machine and ran off with it. Yeah, so that's the kind of thing that can happen. So this is a lot of theory here. In a winding up, it can be quite a free for all. Yeah.
I think we were a party to that action sometime back. It went up with the Supreme Court.
They have been properly advised.
Yes. They took off the...
That was at B, by the way.
That's right.
Just to add to what Mr. Rodriguez said, it's very unlikely that a secured creditor will give up, because he can still realize his asset and then stand in line for the balance. So it makes no sense for him to ever give up his security, though he could, and come into the normal things. So what happens most, like Mr. Singh said, was the banks are at the very top of the pile. So they will first and foremost realize the asset, and if there is anything left, they will stand in line. But like we just saw earlier, the secured creditor is left holding the can and maybe a juki machine at the end.
Very well. Thank you for this thoughts and sessions. I think with that, let me hand over to Isuri Jayawardena, attorney at law, to deliver the vote of thanks. Thank you. Thank you to you.
Thank you, Janaka.
Thank you.
Thank you.
On behalf of the Bar Association of Sri Lanka, we would like to thank all the panelists, all our eminent panelists, for sharing their knowledge and experience with us today. Mr. Palatha Kumarasinghe, President's Counsel, Mr. Avinda Rodrigo, President's Counsel, Mr. Hiran Dialviz, Attorney at Law, and Mr. Lakshman Jayakumar, Attorney at Law, and Mr. Janaka Basurya, Attorney at Law. Thank you very much for your valuable contribution for the session today. We would also like to thank the Bar Association of Sri Lanka, the President, Secretary, and the Executive Committee for the series of webinars organized by them as a part of the Professional Development Program of the Bar Association of Sri Lanka. Stay safe and well, and good night to all of you.
Right. Bye. Thank you.
Thank you, Pali.
Thank you.
Thank you.